This is the case of Roy Dessado versus Jennifer Brown. This case falls under the Property Rights of Spouses Act. And there is also the Limitation of Action Act. Okay, now this is yet another case under these acts, on the Property Rights of Spouses Act. Now, if you are married, or you plan to get married, or to live with someone for more than 5 years, then you need to know the legal implications of your decisions. All right? I've already read through the entire Property Rights of Spouses Act. I want you to check that out, read through it with me. Let me also remind you to subscribe to this channel if you haven't done so already, and to look at the videos and links that are in the description below this video. Now, let's look at this case. In the Supreme Court Judicature of Jamaica, in the Civil Division, you have the claim number here, between Roy Dessado, applicant, claimant, and Jennifer Brown, who is the respondent slash defendant. In chambers are Mr. Nicholas Jarrett, attorney, instructed by Mackenzie Howell and Company for the claimant. So Mr. Nicholas Jarrett is Mr. Dessado's attorney. Mr. Jermaine Campbell, instructed by Williams and Campbell for the defendant. So Mr. Jermaine Campbell is Jennifer Brown's attorney. January 17, 2022, and it was delivered in March 8, 2022. Property Rights of Spouses Act, Common Law Property. Application to make claim for division of a family home. There is delay, prejudice, and whether the overriding objective can be preserved in the granting or non-granting of the extension of time, Limitations of Actions Act, and adverse possession. Remember, adverse possession would mean that, for example, if you are living somewhere for so long that the owners of the place have in law abandoned it, and you are able to get a title for that place due to the length of time that you've been living there undisturbed. Introduction. The parties to the claim began a common law union in 1989, which irretrievably broke down and ended in 2002. So 89, 2009, 9, 10, 11, 12. So this is 23 years. So you see, no matter how long you've been living together or married, the day may come where you both find yourself in court. This is 22 years. Some even after 30 years. Anyway, we continue. In 1997, during the common law union, the parties purchased property located at 2 Vilma Avenue, Kingston 20, Hewenden, in the parish of St. Andrew, and registered at volume 1054 and folio 54 in the registered book of titles. That's called the property in this case, which they currently own as joint tenants. An application was made by the claimant, that's Mr. Dessado, under the Property Rights of Spouses Act by way of a fixed claim filed on the 5th day of October 2020. Hold on. It broke down in 2002. And now in 2020, that's 18 years later. An affidavit in support filed on the same day outlines the basis of his claim to an interest in the property. So after 18 years, the claimant, Mr. Dessado, seeks the following orders of the court. 1. A declaration that the property situated at 2 Vilma Avenue, Kingston 20 in the parish of St. Andrew, comprised in the duplicate certificate of title registered at volume and folio 34, it left out the volume number here, in the registered book of title was the family home and shared between the claimant, applicant, that's Mr. Dessado, and his ex-spouse, the defendant, that's Miss Jennifer Brown. All right. A declaration that Mr. Roy Dessado is entitled to 50% of the share, 50% share, and interest in the property situated at 2 Vilma Avenue, Kingston 20, Uwenden, in the parish of St. Andrew, comprised in the duplicate certificate of title registered at volume 1054 and folio 34 of the register book of title, which was the family home. 3. An order that the property be valued within 30 days by a registered appraiser appointed by the Supreme Court. The cost of the appraiser is to be borne equally by the parties. The attorney for the defendant raised a preliminary point, which was that so the defendant is Miss Brown, Jennifer Brown. So Miss Brown's attorney raised a preliminary point, which was that there was an irregularity in the application for the division of property because it was made outside of a 12-month period prescribed under the Property Rights of Spouses Act. So you have 12 months, although the court can still consider the case after 12 months. It was submitted that an application should be made to seek the court's permission to file the claim as the time for doing so exceeded the maximum 12 months prescribed under the Property Rights of Spouses Act. Counsel for the claimant, that's Mr. Roy Dessado, in response, filed an application for an extension of time within which to bring a claim under Section 13 of the Property Rights of Spouses Act for an interest in the property. I was asked to determine on the application pursuant to Section 13, subsection 2, whether time should be extended for making an application for division of property where the application was made 18 years after the parties separated. The attorney at law for the claimant, that's Mr. Roy Dessado, filed the application for extension of time pursuant to Section 13 of the Property Rights of Spouses Act on the following grounds. 1. The parties were previously in a common law relationship. So these are the grounds on which Mr. Dessado filed the application for extension, right, of the time that the parties were previously in a common law relationship. that the parties separated in or about the year 2002, that the property and subject matter of the instant claim was acquired during the course of the common law union. They acquired the property during the common law union and was the family home of the parties. 4. The overriding objective should be considered in the granting or refusal of the extension of time. Counsel for each party was asked to make written submissions, and the matter was adjourned to January 17, 2022. In their submissions, counsel for the parties relied on Section 13 of the Property Rights of Spouses Act, as well as several authorities on the point. We'll look at submissions by the parties in another video.